Imagine this. You've poured countless hours, maybe even years, into an invention. You file your patent application, you craft your claims, and then, bang, the final rejection from the examiner.
Yeah, that's a tough moment. Feels like hitting a wall sometimes.
It really does. But it's definitely not the end of the road, right? It's often just the start of the next phase.
Exactly. A crucial phase.
Welcome to the deep dive, where we take a stack of information and, well, we distill the important stuff, giving you that shortcut to being really well informed.
And we're continuing our journey through the Manual of Patent Examining Procedure, the MPP, section by section.
That's right. Today, we are diving squarely into Chapter 1200, which is all about appeal. And our mission specifically is MPP Section 1205, the appeal brief.
Yeah, we're going to unpack what it is, why it's so incredibly important in the whole appeal process.
And exactly what needs to be in it to give your appeal the best possible shot. Now, just as your guides here, we need to be clear. This deep dive is a summary. It was generated with help from AI tools.
Right. It's for general educational, informational purposes.
Yeah.
It's definitely not legal advice.
Absolutely. For the authoritative stuff, you always need to consult the official MPP itself, or, a qualified instructor or a registered patent practitioner.
Definitely.
Okay, let's unpack this first step. So you get that final rejection. You decide, nope, I'm fighting for this. You file a notice of appeal.
Right. That's your formal flag to the USPTO saying, hey, I disagree, I want a higher review.
But that notice, it's really just the ticket to the game, isn't it? The real argument, the substance, that happens in the appeal brief.
That's exactly right. And it comes with a very strict deadline and pretty significant consequences, too.
Yeah, I was surprised. According to the rules, 37 CFR 41.37, you have to get this brief in within 2 months of filing that notice.
2 months. It sounds like a decent amount of time, but given what needs to go into it.
It's really not much time at all. And what's also striking is, okay, there's no separate fee right now just for filing the brief.
Correct. No fee for the brief itself.
But if you miss that deadline, if you don't submit it on time,
it's a deal breaker. Simple as that. The appeal gets dismissed.
Wow. Okay.
And connecting that to the bigger picture, a dismissed appeal could be devastating.
How so?
Well, think about it. If the examiner hasn't allowed any of your claims, right? If everything's rejected,
yeah,
then a dismissal, just because the brief was late, can lead straight to the abandonment of your entire application.
The whole thing just gone.
Oof. Yeah. All that work potentially just gone. Which really brings up the question, why is this document, this appeal brief, so critical?
Right. It sounds like more than just ticking a box.
Oh, absolutely. It's not just bureaucratic red tape. It is quite literally your main chance, often your only chance, to lay out your full legal argument for the Patent Trial and Appeal Board, the PTB.
So anything you don't put in the brief,
they won't consider it, period.
Okay. So given that, how do you actually put together an effective brief? It's clearly not just, writing a letter saying I disagree.
No, definitely not. The MPP lays out very specific mandatory sections. You really have to think of it like building a case, like constructing a legal argument with a really precise blueprint.
A blueprint, I like that. So every part has its place.
Exactly. Let's dive into those foundational elements. First up, you have to identify the real party in interest.
Okay, that sounds straightforward. Just saying who owns the application.
Well, yes, but it's more than just stating a name. It's crucial for establishing the legal right to even take action on the application.
Ah, okay. Legal standing.
Precisely. It ensures total clarity on ownership, which is vital, especially when a patent is actually granted. The USPTO needs to know exactly who holds the rights.
And when do they need to know that by?
Well, that notification has to happen no later than when you pay the issue fee. And the MPP is clear, you have to meet the specific requirements of the rules, 37 CFR 3.73, to be recognized as the owner who can act.
So it's about preventing confusion, making sure the right entity is involved.
Exactly. Legal certainty prevents challenges later on.
Makes perfect sense. Okay, so you've nailed down who's actually in charge. What's the next required section?
The next is related appeals or legal proceedings.
Ah, disclosure.
Right. You have to tell the board about any other ongoing appeals, court cases, anything related that might affect this application.
Why is that important? Context.
Context, exactly. It gives the board the full picture, the whole IP landscape around your invention, helps them understand potential overlaps, maybe even conflicting decisions elsewhere. It's about transparency.
Okay. So real party and interest, related proceedings. What's third?
Third is a summary of the claimed subject matter.
So it's just copy-pasting the claims?
No, not just that.
Oh, yeah.
This is your chance to explain, sort of in plain English, what your invention is, a concise overview.
Like an abstract for the board?
Kind of, yeah.
Yeah.
Before you dive into the legal arguments, you give them the essence of the invention, what you're trying to protect. It sets the stage.
Okay, that makes sense. Give them the big picture first.
Precisely. And then we get to what I'd call the absolute heart of the brief.
The main event.
Definitely. The arguments addressing each rejection. This is where you directly tackle everything the examiner rejected you on, point by point.
And you said earlier, specificity is crucial here.
Absolutely critical. Specificity is king. Because, like we said, any argument you don't include right here in this section,
The board won't consider it?
won't consider, full stop. And each specific rejection you're arguing against needs its own clear, distinct heading. You can't just lump things together vaguely.
Okay, hang on. This sounds like a place where you could easily mess up. Give me an example.
Sure. Let's say you have claims 1, 2, and 3. And the examiner rejected all of them under 1 under 2, saying they're anticipated by some prior patent.
Anticipated meaning. Already known.
Essentially, yeah. The examiner thinks the invention, as you've claimed it, was already described before you filed. Now, let's say you write your argument, but you really only focus on why claim 1 gets around that prior patent.
Okay.
If you just kind of generally refer to the claims or don't specifically argue for claims 2 and 3, the board might just assume claims 2 and 3 stand or fall with claim 1.
Ah, so if claim 1 loses, claims 2 and 3 might automatically lose too, even if they have unique features.
Exactly. That's the danger. You could lose protection for those specific, maybe crucial, unique aspects in claims 2 and 3 simply because you didn't argue for them separately.
Wow. Okay. So if claims 2 and 3 add something specific, like a different material or an extra step.
You absolutely must give them their own subheadings and their own specific arguments explaining why they, independently, are patentable over that rejection.
That level of detail is intense.
It is. It prevents the board from making assumptions, ensures each claim gets its due, and the rules even drill down further for specific claim types.
Like what?
Like means plus function claims, where you define something by its function rather than its structure.
Right, under Section 112.
Exactly. For those, the MPP says you must point to the specific structures, materials, or acts in your written description, your specification, that perform that function. And you have to cite the page or paragraph number.
So you have to explicitly link the function in the claim to the structure in the description.
You got it. It really shows how the technical details and the legal requirements are tightly interwoven.
Okay, so when you're crafting these arguments, what kinds of rejections are common? You mentioned anticipation.
Right. Anticipation under 102 is one. Another big one is obviousness under 35 U.S.C. 103.
Obviousness. Meaning even if it's not identical to prior art, it would have been, well, obvious to combine things.
Pretty much. The examiner says someone skilled in the field, looking at the existing prior art at the time you invented, would have found your invention obvious.
How do you fight that? Seems subjective.
It can be tricky. The key is avoiding what's called hindsight bias. You can't argue based on knowing your invention exists.
Right. You have to argue from the perspective of someone back then without your blueprint.
Exactly. And the Supreme Court case, KSR v. Teleflex, was huge here. It said you need to look at the knowledge of that skilled person at the time.
Did KSR make it easier or harder to argue against obviousness?
Well, it clarified things. It said the reason to combine prior art doesn't always have to be explicitly written down. It can be implicit, based on common sense or market pressures known at the time.
So your job is to show why a skilled person wouldn't have logically put those pieces together without your inventive step.
That's the core of it, demonstrating that non-obvious leap.
Okay. What's another common rejection type?
Enablement under 35 U.S.C. 112.
Enablement. Does your description actually teach someone how to make and use the invention?
Exactly. The examiner might argue that your specification, your written description, doesn't give enough detail for someone skilled in the art to actually practice your invention without unreasonable guesswork or experimentation.
So if the examiner raises that,
the burden shifts to you. You then have to show, usually with arguments, maybe extra evidence like test data or expert declarations, that yes, someone skilled could make and use it based on what you wrote.
you might have to prove it works and is doable.
You might. The case in Rebrandstatter talked about this. If the examiner has a reasonable basis to doubt enablement, you need to provide proof.
Got it. And are there special rules for, say, design claims? protecting the look of
Oh,
something.
yeah, definitely. Design patents are a different beast in some ways.
Right.
The MPEP has specific sections on them.
Like what kind of specifics?
Well, for example, the design's ornamentality. It generally can't be something that's hidden during the normal use of the product.
Ah, like the INRI web case. If you only see the design when you take it apart for maintenance.
Exactly. That might not qualify. And another thing for designs, multiple versions or embodiments.
Can you put different versions of a design in one application?
Only if they're patentably indistinct, meaning they're basically variations on the same core design idea. If they're distinct inventions, they need separate applications. That came out of the Inri-Rubenfield case.
Okay, lots of specific rules depending on the claim type. So we've got real party and interest, related cases, summary, arguments. What's the fifth required part?
The fifth is pretty straightforward. The claims appendix.
Just a list of the claims.
Yep. A clean, clear list of all the claims you're actually appealing gives the board that definitive snapshot of exactly what's on the table for review.
Simple, but essential for clarity.
Absolutely.
Okay, so that's the blueprint for a good brief, but let's talk reality. What happens if the brief isn't quite right? Or, going back to that deadline, what if you miss it?
Right. Not the end of the world necessarily, but it definitely puts you on a different and usually tougher path.
So, missing the deadline.
Like we said, generally leads to dismissal of the appeal. And again, if no claims are allowed.
Application abandoned. That's harsh.
It is. It really underlines how seriously the USPTO treats these deadlines.
But can you get more time if you're scrambling to meet that 2-month window?
Good question. Yes, extensions can sometimes be granted under the rules, 37 CFR 1.136, for that initial brief filing. You usually have to pay for them, but it's possible.
Okay, so there's some flexibility there.
But, and this is a crucial but that trips people up.
Uh-oh.
What is it?
Those general extensions you can buy. They do not apply to the deadline for replying to something called a substitute examiner's answer.
A substitute examiner's answer, when does that happen?
That can happen if the board sends the case back, remands it to the examiner for some reason, and then the examiner issues a new answer.
Okay.
The deadline to respond to that substitute answer is also 2 months, but it's a much harder deadline. You can't just buy extensions under 1.136 for that specific response.
Wow. Okay, that's a really important distinction. Getting that wrong could cost you the appeal right there.
Absolutely. Very costly mistake if you misinterpret the extension rules.
All right. What about trying to slip in new stuff in the brief? Like, oh, I should amend this claim, or here's some new evidence.
Generally, that's a no-go within the brief itself. If you file amendments after the brief is filed, they're usually restricted to just things like canceling claims or maybe rewriting a dependent claim into independent form.
So no major changes or new arguments via amendment after the brief. Not usually. And trying to put new amendments or brand new evidence inside the actual appeal brief itself, that's generally not allowed either.
What happens if you try?
The board might just treat it as a request to reopen prosecution.
Meaning
They'd likely send the case back down to the examiner, putting the appeal effectively on hold, can cause significant delays, more costs. MPP 157.05 flags this. A reply brief with new evidence is seen as asking to reopen things.
Okay, so the brief is really for arguing the case as it stood before the examiner, not for introducing new things.
Largely, yes, it's about arguing the correctness of the examiner's decision based on the record at that time.
So if you do realize you need to make bigger changes or bring in new evidence, what are your options if the appeal brief isn't the place?
Well, one major strategic alternative is filing a request for continued examination, or RCE.
An RCE, right.
Sure.
That pulls the application back from appeal.
Exactly. Under 37 CFR 1.114, you can file an RCE even after you've filed your appeal, as long as the board hasn't issued its decision yet. It reopens prosecution with the examiner.
So it gives you another shot to maybe amend the claim, submit evidence, negotiate with the examiner.
Yes, it resets things back to the examination stage. But there's a timing catch here, too.
Of course there is. What is it?
If you file the RCE after the board has already made its decision on your appeal,
Yeah.
that board decision carries what's called res judicata effect.
Res judicata. Latin for a matter decided.
You got it. It means the board's decision on the patentability of those claims is legally binding on the examiner.
So if the board already said no, filing an RCE doesn't just wipe the slate clean.
Not entirely. You can't just re-argue the same points. You'd typically need to make significant amendments to the claims the board rejected, or submit really compelling new facts or evidence to overcome that prior board decision. Arguments alone won't cut it then.
So it's really not just about trying to win the appeal itself, but understanding all these different paths and procedural options to keep your patent application moving forward effectively.
Absolutely. It's about strategic navigation through the whole system.
Wow. Okay, we have definitely taken a deep dive into MP Section 1205 today. We've looked at the appeal brief's critical structure, why those precise arguments are so vital, and the pretty serious consequences if you don't comply.
It really highlights the level of detail and rigor involved in patent law, doesn't it?
It really does. This appeal brief, it's not just paperwork. It's your main shot to rewrite the story of your invention's patentability, trying to turn that rejection into an allowance.
Mm-hmm. Your chance to persuade the board?
So, as we wrap up, here's maybe a thought for you, the listener. Think about the skills needed to craft a really strong appeal brief. You need absolute clarity, laser precision in your arguments. You need to anticipate counter-arguments.
Right, thinking ahead, structuring your points logically.
Exactly. So the question is, how might embracing those same principles really designed to win a complex legal argument, benefit you in other areas? Maybe in other complex communication challenges in your life. Could be a business proposal, a research paper, maybe even just navigating a difficult conversation.
Interesting thought. Applying that rigor elsewhere.
Something to mull over.
And before we sign off, we definitely want to give a special thank you to Mike Shepard.
Absolutely. Mike's the creative director who organized this entire audio series, making all these deep dives possible.
Yep, thanks, Mike.
Thank you for joining us on the deep dive. We really hope this exploration of MPP Section 1205 has given you some valuable insights, maybe even a bit of a strategic edge in navigating patent appeals.
And just that final reminder, this summary was generated using AI tools, so there might be errors or omissions.
Right. It's purely for general educational and informational purposes. It is not legal advice. It's not a substitute for formal instruction. For the authoritative guidance, you always need to go to the official MPP, talk to a qualified instructor, or consult with a registered patent practitioner.
Absolutely essential.